In this episode, I'm going to talk to you about Diwan Bahadur Sir Tyagaraja Sadasivaya MABL, one of the doyens of the Madras bench, and he has done several cases, both civil and criminal. To give a brief background about Justice Sadasivaya, Justice Sadasivaya was born on 23rd of June 1861 in Kumbakonam, and he was a High Court judge and a theosophist who served as Chief Justice of the Travancore High Court from 1905 to 1910. அந்த காலத்தில் வந்து Travancore was a part of the Madras High Court. So அந்த ஒரு division of Travancore was headed by him between 1905 and 1910. He was also the first president of the Hindu Religious and Charitable Endowments Board of the Madras Presidency. He was elevated to the Madras High Court in 1914. He became an additional judge in 1912. He was confirmed in 1914. He retired in 1921 from the Madras High Court. He lived in Sudar Garden, Mowbray Road, Chennai, Mowbray Road, Thenambed, and he was knighted. He was given the Sir Pattam in 1921, and he died on 24th November 1927 at the age of 66. But there is a little discrepancy in the date. In some journals, they say it is 24th November. In some journals, they say 1st December 1927. So this is the brief background. And to start with, Justice Sadasivaya started his career. He was basically educated in Kumbakonam and mastered the Hindu law. Then Sadasivaya's younger brother, Paramasivaya, was also a judge of the Madras High Court, and he was the father of the Kannada playwright T.P. Kailasam. This is the brief family background. Then we go to the judicial career of Justice Sadasivaya. Sadasivaya started his judicial career as an apprentice to Raja T. Mohan Ram Rao, who was also a doyen of the bar before enrolling as a vakil in the Madras High Court. After joining the service as a district munsif of Madura in 1887 and district judge in 1905, then he was 1905. He was appointed as the chief judge of the Travancore High Court and served till 1910, when he was reverted back to the British service and was posted as a district and sessions judge of Ganja. In 1912, Justice Sadasivaya was appointed as the additional judge of the Madras High Court and served from 1912 till his retirement in 1921. In 1914, he was confirmed. In 1915, he was elected as a vice president of the National Indian Association of Madras. He was also appointed as I said, the president of the HRNCE, which was newly established by the Justice Party at that time, under the government of Raja of Panagal, and he was made the Knight Bachelor of the King's Birthday Honours List in 1921. So this is the brief background. And Justice Sadasivaya was too keen in social reforms, and his articles on social reform topics under the pseudonym of Krishnadasar அப்படிங்கிற பேர்ல நிறைய articles அவர் எழுதினாரு. It was regularly published in the Hindu, and simultaneously he called the Hindu Reformer and Politician ஒரு journal அவர் ஆரம்பிச்சாரு. அதுலயும் அவர் வந்து he wrote a lot of articles on social reforms, and he was also the member of the National Indian Association, which advocated widow remarriage, untouchability, and intercaste marriages. So he had such a revolutionary ideas even in 1914, 1915. He married. He was also an active member of the Theosophical Society and presided over several meetings and served as the General Secretary of its Indian section from 1924 to 1925. In 1918, Annie Besant and leaders of the Home Rule League established the Woods College at Madanapalli as the first national university. Sadasivayar was appointed as its vice chancellor and Rabindranath Tagore was its chancellor. He married his maternal cousin Mangalammai and he had 8 children, 5 sons and 3 daughters. So this is the brief background of Justice T. Sadasivayar. And I will also request Madam to post the picture of Sadasivayar which I have shared with Madam. Madam, can you please post the picture of Justice Sadasivayar, Madam? Madam. So now starting with some of the cases, there are 2 or 3 cases which I want to narrate to you. One is the famous Pandi murder case, in which he presided over, and the other 2 cases are reported in the Tamil Nadu Law Journal. The one is the most Hindu religious endowment, whether the sannyasi of a mutt is personally responsible for the debts of the mutt. It is reported in the case of Lakshmi Tirtha Swami Minor versus K. Raghavendra Rao in 1920, volume 2, volume 39, page 174. It was a division bench judgment. And the next case, which I am also going to talk to you about, is the Appala Narayanaswamy and Gupta and others. So, criminal case is reported in 1921, volume 40, MLJ. And then we will have the most important question on the Hindu law, joint family property and business. In the case of Muthu Reddy versus Chinnasamy Reddy, reported in 1921, volume 40, MLJ, page 486. And apart from this, we are going to also have a glimpse of the Gandhi murder case. So this will probably bring forth the mastery of Justice T. Sadasivayar in both the civil and the criminal law. Now, going to the famous Pandi murder case, this case was a classic wood unit that aroused public feeling to a feverish pitch. It concerned the family of a Zamindar in Tanjore district, and there was a domestic misunderstanding in the family, and it culminated in a gruesome murder. Every individual in the family was held as a suspect, and the father and son accused each other of the dastardly crime. The trial took place in a tense atmosphere. There were no eyewitnesses to the crime, and those who came forward to give evidence were themselves made an accused in the said case. The case presented many such remarkable features, and the sensation it created did not abate for some years, even after the trial was over. So, this is the background of the anti-murder case. The entire case revolved around a wealthy landowner called Vaidyanath Pillai, who was a married man. He was about 52 years at that time. He lived in Pandi village and he had the reputation of being both a tyrant in the house and outside. He earned the hostility of his own brother Somudeva and his 3 wives bore him 3 children. He had 3 wives and they had 3 children. The first son was Ayasami, who was aged 25 at the time of the crime. Then the next was Somu Kalyana, who was aged 60. And the third was a daughter, Tangam, who was a child widow at that time. The eldest son, Ayasami, was a dim-witted fellow and often exhibited symptoms of insanity. He was married to Dhanam. And Dhanam was a very clever woman who manipulated Ayasami to suit her own needs. and they had 2 children. Most of the time, Dhanam was staying, the couple Ayyasami and Dhanam were staying with Dhanam's parents, whilst the other 2 children, Somu Kalyanam and Tangam, were staying with the father, Vaidyanatha. So this is the scenario. In early 1905, there were instances where Ayyasami exhibited bouts of insanity, which were very violent. He was beating his children and his wife also. And as a result of which, the parents of the wife, that is Dhanam, wanted them to leave their house and go to Ayyasami's parents' house. ஏன்னா அவங்க மாமனார் வீட்டில் தான் இருந்தார் அவரு. So now, because of this violent bouts of violence, the father-in-law, that is Dhanam's father, wanted them to shift back to Vaidyanatha Pillai's house. So இதுதான் வந்து ஒரு பேக்ரவுண்ட். In 1911, September 1911, they shifted to Vaidyanatha Pillai's house and they were living as a joint family. In the meantime, Tangam also had a problem. The Tangam is the sister of Ayyasami and daughter of Vaidyanatha Pillai. Also had a problem with her in-laws and she had to come back. So now the fact is, all the children were living under the same roof with the father, Vaidyanatha Pillai. இந்த நார்மலா இருக்கிற மாதிரி there were also other misunderstandings and relationship. Dhanamukkum Tangamukkum அடிக்கடி used to have a problem, and as a result of which it led to a lot of misunderstandings between the family. So in 1911, Deepavali, and the 1911 Deepavali, this incident took place at that time, Deepavali போது. So Dhanam வீட்டுல இருந்து சீரெல்லாம் வந்தது. That is Ayyasami's wife, Dhanam. வீட்டுல இருந்து Dhanam's presents எல்லாம் வந்தது. So Dhanam, what she did was, she kept all the presents, presented it before Vaidyanatha Pillai, her father-in-law, and said that, these are the presents which I am bought from my in-laws place, and as a இதை வந்து நீங்க எல்லாருக்கும் நீங்க யார் பண்ணுவோம் நீங்க கொடுக்கலாம் அப்படின்னு சொல்லி she gave. And this caused a lot of people, இதுல இருக்கிற மிஸ்அண்டர்ஸ்டாண்டிங்ல இதெல்லாம் இந்த மாதிரி ஒரு கான்டாக்ட் வந்து eased the relationship between the father-in-law and the daughter-in-law. So this is the scenario. On 22nd October 1911, that is a fateful night when the bloody act took place, which nobody anticipated. So அந்த ஒரு ஜமீன்தார் house, ஒரு பெரிய வீடு. So Vaidyanatha Pillai was sleeping in the front portion of the house. Then there was a big screen. And the screen க்கு அப்புறம் Ayyasami and his wife were sleeping. And then அந்த ஸ்கிரீனுக்கு அந்த பக்கம் Ayyasami's mother, Muttachi, was sleeping in that. And the lamp was burning. The சின்ன lamp was burning because there was not much of electricity lamp அங்க இல்லாதனால. There was a lamp. The night was very silent and peaceful. And at about 2 a.m., there was a very loud noise. So Muttachi என்ன பண்ணாங்க, Ayyasami's mother woke up and went straight to Ayyasami. அந்த இடத்துல ஒரு terrible, she was confronted with a very terrible sight. Ayyasami was standing next to his wife, clad in a white cloth and holding a sickle, ஒரு அருவா. Dhanam was cut into pieces and the blood was all over. So the mother was shocked to see this and said, என்ன Ayyasami, ஏன் இப்படி பண்ண அப்படின்னு சொல்லி கத்துறாங்க. இவங்க கத்தும் பொழுது அந்த பீப்புள் அப்ப அங்க இருந்த சர்வெண்ட்ஸ், Vaidyanatha Pillai எல்லாருமே வந்து எழுந்துட்டாங்க. எழுந்து then they went and they saw Dhanam cut to pieces. So nobody though everybody knew it was Ayasami who did it because there was nobody there, nobody wanted to அவரை காட்டி கொடுக்கறதுக்கு அவங்களுக்கு மனசு வரல because he was the eldest son of the family. The death was instantaneous and the கழுத்து அப்படியே ஃபுல்லாவே விட்டிருந்தார். The entire head was severe from the body. Then what happened? After this, it was at 2 a.m. and at 6 a.m. they were sent. The word was sent to the village Mulsi and all the other relations. They all came to the scene at 6 a.m. and the matter was communicated to the police. An inquest was held at 4 p.m. and the report fixed the guilt of Ayasami, who was arrested and tried. Background. This is the brief prelude to the entire trial. On 27th October 1911, Ayasami denied the guilt and gave a shocking statement to the magistrate. He said that on the fateful night, he went to bed and at midnight his stepmother, sister, Tangam, and brother Kalyanam came to his room and pressed Dhanam to her bed while his father cut her off with a sickle. ஐயாசாமியோட கதை என்னன்னா, he said that it was his father who committed the murder and not him. On 22nd November 1911, at the preliminary trial, Muttachi and Somu Devan is the brother of Vaidyanatha Pillai, gave evidence and pointed out Ayasami as the murderer. அவங்களும் அந்த எவிடன்ஸ்ல ஐயாசாமி தான் மர்டரர், நாட் வைத்தியநாத பிள்ளை. On 20th December 1911, one of the family servants, Tyagan பேரு, turned approver and made a confession. He was granted pardon. His statement was to the effect that Dhanam was decoyed to a cattle shed. The members of the family held her down. Vaidyanatha Pillai stood by and commissioned two unknown persons to finish them. That is, he hired hirelings to finish off Dhanam. Vaidyanatha Pillai stood by and commissioned two unknown. When that was done, the blood-stained cloth was taken and Ayasami was forcefully covered in that. Version of the was made by Tyagan, who was one of the servants. So different people said different versions of the Muttachi and Somu Devan said that Ayasami was the murderer. Tyagan said Vaidyanatha Pillai was the murderer. Ayasami said his father was a murderer. So these are the three versions in the entire trial which the magistrate confronted. Ayasami gave a different version from his earlier statement. He said that அவரோட இன்னொரு வருஷன் என்னன்னா, he said that his sister Tangam took his wife to a cattle shed and there the wife was killed by his father and his associates. அப்படிங்கிறத அந்த வருஷனை வந்து இந்த தங்கம்ங்கிற ஒரு டைமென்ஷனை உள்ள கொண்டு வர்றாரு ஐயாசாமி. So in view of these three versions, the magistrate discharged Ayasami, and meanwhile suspecting the complexity, the other members of the family, and the magistrate issued warrants against Vaidyanatha Pillai, his wife, daughter, and the other people. And except two others were all apprehended and brought before the magistrate on 4th January 1912. The other members of the family were charge sheeted for murder. Vaidyanatha Pillai had a fracture of the bone on the right forearm and was physically incapable of using it. He was hence charged as an abettor and not as the actual killer. The accused were committed to trial. At the trial, the allegation was made against Vaidyanatha Pillai that he tried to seduce Dhanam and had illicit intimacy with his own daughter. So this was the various dimensions statements that were given before the magistrate, and Vaidyanatha Pillai was convicted for abetment of murder and sentenced to death by the magistrate, by the sessions judge. Sorry. The matter went on appeal to the High Court, and in the High Court, Justice Bakewell, single judge, upheld the conviction and sentence. But Sadasivaya held that Dhanam was done to death by Ayyasamy in a fit of homicidal mania, and that his father had suffered great prejudice during the trial. So, since there was a difference between the two judges, the matter was referred to a third judge, Justice C. Sankaran Nair, another Doyen, who agreed with Bakewell and confirmed the sentence of Vaidyanatha Pillai. The matter then went on appeal to Privy Council. Privy Council held that a lot of inadmissible and false testimony had been admitted and acted upon. The Privy Council asked itself if the evidence of Ayyasamy and Tyagan was insufficient against the other accused, how could it be sufficient against Vaidyanatha Pillai? Now, considering this, it's a turning point in this case, where it was held that when the when the evidence of the two were found to be insufficient and the others were discharged or acquitted, some of them, how could that evidence be sufficient only against one accused, that is Vaidyanatha? Concluding that a grave injustice has been caused in this case, the Privy Council acquitted the accused and set him at liberty. The curious part of the case was that Muttachi's evidence, that is Muttachi's Ayyasamy's mother, was given less weight than it deserved at the trial. Ayyasamy too made radically different statements, which also could not be taken as reliable. There were 13 cuts on Dhanam, which pointed out a homicidal mania rather than a premeditated murder. It was, if there was a hired assassin who was used to kill Dhanam, there need not be 13 cuts in the body, because a one swipe of the Aruvad would have finished Dhanam. So the concept or the version that assassins were hired was Dhanam, and also Dhanam was also responsible for separating the father and the son, and she was playing politics between the father and the son, because there was a lot of lands, there was a lot of wealth to be distributed between the father and the children. So she probably thought she can get more out of this through her husband than anybody else. So this was the long and short of this Pandi murder case, which went on for more than a year, and the amongst the three judges who heard this case, it was Sadasivayar alone who took the view that it was a homicidal mania murder, because Ayyasamy had bouts of insanity and he could have done it during those period rather than as a premeditated murder. So Sadasivaya Iyer's judgment was upheld by the Privy Council, and the accused, Vaidyanatha Pillai, was acquitted. From the facts and evidence, it became clear, it does appear, as Sadasivaya held, that Ayyasamy, being of an unsound mind, had done away with his wife in a fit of homicidal mania. So this was one of the, which shows the clarity of the man, how the murder could have taken place, what were the preponderance of probabilities, how it could have been done only by Ayyasamy and not by others. And hence, because of the insanity of Ayyasamy, even today, I think everybody, I mean, nothing could be done because of the insanity of Ayyasamy. It was proved he was not sentenced. So this is in brief the Pandi murder case, which took the entire Madras by storm in 1910-1911. During that period, the talk of the corridors of the High Court was only the Pandi murder case, which had a tremendous repercussion on the law of evidence. And if you read that case, we had three Indian judges or three Madras judges who sat: Justice Bakewell, Justice Lasivayar, and Justice Shankaran Nair. All the three were Doyens of the bench at that time. And out of these three, it was Sadashivayar alone who was able to give clarity to the entire case. Now, I put it in a nutshell. The entire case, the Pandi murder case, took place in 1911 in a village called Pandi. And இப்போ கேட்கறதா உங்களுக்கு எல்லாருக்கும்? Okay, thank you. And the entire murder revolved around a landed zamindar called Vaidyanatha Pillai, who was aged 52 at that time. He was married to Muttachi, and அவங்களுக்கு வந்து 3 பசங்க இருந்தாங்க. ஒன்னு வந்து ஐயாசாமி, ரெண்டாவது வந்து சோமுதேவன், மூணாவது வந்து தங்கம்னு ஒரு டாட்டர் who was a child widow. ஐயாசாமிக்கு அந்த சமயத்துல வந்து at that point of time he was aged 25. Somu Kalyanam, the second son, was aged 16, and Tangam was aged, she was a child widow. Vaidyanatha Pillaiku, he had 3 wives, and each wife had a son. So Ayyasami was the son of Muttachi. So adu muttum dhaan namakku vandu we are very clear about that. Ipo Ayyasamiye portha mattum he was suffering from bouts of insanity, as a result of which he used to be violent, and sometimes he used to beat his wife Dhanam. So அந்த சமயத்துல வந்து என்னாச்சுன்னா, தனம் இந்த மாதிரி ஒரு வயலன்ஸ் இருக்கிறதுனால தனம் had to stay with her father, and Ayyasami also was staying with his father-in-law. And அங்க வந்து சில சமயங்கள்ல வயலன்ஸ் வரதுனால the father-in-law asked Ayyasami and his daughter, that is a son-in-law, to go back to his parents' house, that is Vaidyanatha Pillai's house. So this is the brief background. So எல்லாருமே வந்து ஒரே இதுல இருந்தாங்க. தனம், I mean Tangam, who is the child widow, also came back, and Somu Kalyanam was also there. Then Somudevan is Vaidyanatha Pillai's brother. அவரு அங்கதான் இருந்தாரு. So all of them were staying in the same roof. இந்த ஒரு சூழ்நிலையில both Dhanam and Tangam, that is the sister-in-law of Dhanam, அடிக்கடி அவங்களுக்குள்ள ஒரு தகராறு நடக்கும். வீட்டுக்குள்ள பல தகராறுகள் நடக்கும். இப்ப பார்த்தாலும் ஒரு lot of confusion, and it was very chaotic அப்படி சொல்லிட்டு இருந்தாங்க. chaotic. Vaidyanatha Pillai was a tyrant. அவர் வந்து both inside and outside the house he was a tyrant, and he was feared by a lot of people. So that is the character of Vaidyanatha Pillai. So September 1911ல இந்த தீபாவளி நடக்கும் அந்த ஒரு சமயத்துல வந்து தனமுடைய பேரண்ட்ஸ் சென்ட் a lot of அந்த சீரெல்லாம் அனுப்பிச்சாங்க. ஸோ அந்த சீரெல்லாம் அனுப்பும்போது தனம் என்ன பண்ணாங்க, இதெல்லாம் வந்து வைத்தியநாத பிள்ளைய முதல்ல அவருக்கு காமிச்சுட்டு அப்புறம் எங்களுக்கு எல்லாம் கொடுங்க அப்படின்னு சொல்லிட்டாங்க. ஸோ தட் அப்போ அந்த ஒரு டென்ஷன், அந்த ஒரு கயாஸ் இருக்கிற சிச்சுவேஷன் வந்து கொஞ்சம் டிஃப்யூஸ் ஆச்சு பிகாஸ் ஆஃப் தி பிஹேவியர் ஆஃப் தனம். ஸோ அந்த சீரெல்லாம் வந்து வைத்தியநாத பிள்ளையோடைய இதுல கொடுத்துட்டு, அவங்க கையில கொடுத்துட்டு, நீங்க எல்லாருக்கும் பார்த்து கொடுங்க அப்படின்னு சொல்லி தனம் சொல்லிட்டாங்க. So this is what was the scenario on 22nd September 1911. இது ஒரு மாசம் இப்படி தள்ளி போகும்போது on 22nd October 1911, that is a fateful day when Dhanam was murdered. அந்த அப்ப வந்து அப்ப அவங்க ஒரு பெரிய ஒரு ஜமீன்தார் வீடு அது. அங்க ஃப்ரண்ட் போர்ஷன்ல வைத்தியநாத பிள்ளை வாஸ் லையிங் டவுன். நடு போர்ஷன்ல தனம் அண்ட் ஹஸ்பண்ட் ஐயாசாமி பிள்ளை லையிங் டவுன். மூணாவது போர்ஷன் இருந்தது, அதுல வந்து முத்தாச்சி அண்ட் அதர் சர்வெண்ட்ஸ் வேர் ஸ்டேயிங். முத்தாச்சி இஸ் தி மதர். திடீர்னு ஒரு 2 மணிக்கு ஒரு சத்தம், ஒரு பெரிய சத்தம் அது. உடனே முத்தாச்சி என்ன பண்ணாங்க, எழுந்து போய் பார்த்த உடனே ஐயாசாமியோட ரூமுக்கு போய் பார்த்த உடனே அங்க வந்து தனம் வாஸ் லைங் இன் அ பூல் ஆஃப் பிளட். சரமாரியா வெட்டியிருந்தார் ஐயாசாமி. சோ அந்த ஹெட்டே வந்து ஒரு மாதிரி துண்டிச்சு போச்சு. 13 கட்ஸ் இருந்தது பாடியில. வெரி குரூசம் மர்டர். சோ அந்த ஒரு சிச்சுவேஷன்ல முத்துசாமி முத்தாச்சி என்ன சொன்னாங்க, ஏன் இப்படி பண்ண, ஏன்டா இப்படி பண்ண அப்படின்னு பையனை பார்த்து கேக்குறாங்க. அந்த பையன் அப்படியே போய் நிக்கிறான். அவனுடைய அந்த வெள்ளை வேஷ்டி எல்லாமே வந்து பிளட் ஸ்டெயின்டா இருக்கு. So this is how the body was, the body of the dead woman presented a ghastly sight with 13 wounds inflicted on the left side. The left side of the neck had been cut through. It was actually severe. Actually, and the death was instantaneous. Now the question is, was it Ayasami who killed her? That was the question. Though everything seemed that Ayasami had killed his wife, was it the truth? So இதுதான் வந்து கேள்வி. That was what was posed before the court. So words were sent to the village munsif, and 6 மணிக்கு அவங்க எல்லாம் வந்தாங்க village munsif to ஒரு inquest பண்றதுக்கு. The inquest was held at 4 p.m. and the matter was communicated. Ayasami was arrested and tried. 4 days afterwards, 27th October 1911, he went back on his statement. He said he denied his guilt and gave a shocking statement to the trying magistrate. He said that on the fateful night, he went to bed, and at midnight, his stepmother, sister Tangam, and brother Kalyanam came to his room, pressed down Sanam to her bed, while his father cut her with a sickle. இதான் அவன் சொன்ன ஒரு next statement. Whilst the servants were holding him in restraint, his father committed the murder அப்படின்னு ஐயாசாமி சொல்றாங்க. He gave a statement. On 22nd November 1911, the preliminary trial, Muttachi and Somudevan gave a statement that it was Ayasami who committed the murder. On 28th December 1911, one of the family servants, Tyagan, became an approver, turned an approver, and made a confession. He was granted pardon. His statement was to the effect that Dhanam was decoyed to a cattle shed. The members of the family held her down. Vaidyanath Pillai stood and commissioned 2 unknown persons, assassins, to finish her. When that was done, the blood-stained cloth was taken and Ayasami was forcibly covered with it. Both he and Ayasami gave evidence which pointed out to the guilt of Vaidyanath Pillai and other family members. When Ayasami himself spoke, he gave a different version. இந்த 2 வெர்ஷன் இருக்கு. ஒன்னு ஃபர்ஸ்ட் வெர்ஷன் ஐயாசாமி committed the murder. 2, the second version is Dhanam was taken to the cattle shed where she was killed by the assassins. மூணாவது வெர்ஷன், that is ஐயாசாமி's another version, is that his sister Tangam took Dhanam to the cattle shed and the wife was killed by his father. So the 3 versions are there. So after hearing these and the evidence, the magistrate discharged Ayasami. Meanwhile, suspecting the complexity of the case of the other members, the magistrate issued warrants of arrest against Vaidyanath Pillai, his wife, daughter, son, and servants. They were apprehended and brought before the magistrate on 4th January 1912. The other members of the family were charge sheeted with murder. Vaidyanath Pillai had a fractured bone on the right forearm and was physically incapable of using it. Hence, he was charged as an abettor and not as the actual killer. The accused were committed to trial. At the trial, the allegation was made against Vaidyanath Pillai, and he tried on the ground that he tried to seduce Dhanam and that he had an illicit sexual relationship with his own daughter. So Vaidyanatha Pillai was convicted for abetment of murder and sentenced to death. Sir, sorry,
Now audible, sir.
audible? Am I audible?
Yes, sir. Audible, sir. Audible, sir.
Thank you, thank you, thank you. So now that he was sentenced to death, the matter came up before the High Court. So High Court it came up before a bench of Justice Bakewell and Justice Sadasivaiyer. Bakewell upheld the conviction. Sadasivaiyer acquitted the accused. Since there was a difference in the opinion of the division bench, the matter was referred to a third judge, Justice C. Shankaran Nair, who was also a doyen of the bench at that time. And he agreed with Justice Bakewell, and Vaidyanatha Pillai was sentenced to death. So Vaidyanatha Pillai he went to the Privy Council, where he appealed against the judgments of Justice Bakewell and Shankaran Nair. The Privy Council also found that there was a great injustice done to this case and to Vaidyanatha. They found if the evidence of Muttachi and Tyagan was insufficient against the other members of the family who were later discharged, how come that evidence is sufficient as far as Vaidyanatha Pillai is concerned? So on that ground, Vaidyanatha Pillai was discharged and acquitted. So now considering this, the case, the curious part was that Muttachi's evidence was given less weight than it deserved in the trial. Ayasami too made certain radically different statements which were not weighed because he had given different statements at different points of time. And this raised a reasonable doubt, should have raised a reasonable doubt in the minds of the judge. So there were 13 cuts in the body of Dhanan, and it could only be done by a person who was suffering insanity or a homicidal mania, rather than a premeditated murder. If the version of Ayasami is true, that his father had hired assassins, there was no necessity for 13 cuts in the body. That was what was said by Sadasivaiya. Assassin on the ஒரே வெட்டில he would have finished the number. There was no necessity for him to inflict 13 wounds on the body. So the judgment of Sadasivaiya was upheld by the Privy Council, who later discharged Vaidyanatha Pillai. And amongst the three judges of the Madras High Court who heard this case, it was Sadasivaiyar's version and judgment which was eventually upheld by the Privy Council. From the judgment of Sadasivaiya, who had held that Ayasami, being of unsound mind, had done away with his wife in a fit of homicidal mania. So the case was put to rest and Vaidyanatha Pillai was acquitted and discharged. So this was one of the famous cases which was heard by Justice Sadasivaiya, whose clarity, his precision, and clinical analysis was upheld by the Privy Council. And in a complicated case like this, where two judges were in favor of conviction of Vaidyanatha Pillai, it was Justice Sadasivaiya's judgment which helped Vaidyanatha Pillai to be acquitted from this gruesome murder. So now we have seen the Pandi murder case, the brief facts of the Pandi murder case, which brought to light the enlightened clarity of judgment of Justice T. Sadasivaiya. The next, we are going to another judgment, which is reported in 1921, volume 40, MLJ 484, on a technical plea under section 250 and 253 of the Criminal Procedure Code. Whether the compensation which was granted by the magistrate without examining the witnesses of the complainant can be taken on record and the accused can be exonerated. This case again came up before a bench of the Madras High Court in the case of Jonalagada Appala Narayana Sayya and others versus the state. Accused in calendar case number 109 of 1919 on the file of the subdivisional first class magistrate Vijayanagaram division. In the காலத்து case it was that is how it referred to the bench was presided by Justice Sadasivaiyer along with Justice Napier. Most of the bench judgments were presided over by Justice Sadasivaiyer along with Justice Napier, most of them. The case referred for orders of the High Court against Section 438 of the CRPC passed by the Sessions Judge Vijayanagaram Division in his letter number 456 dated 20th February 1920. In the case V.L. Yathiraj, one of the famous Doyens of the bar, appeared for the prosecution. He was the crown prosecutor. And the accused Satyanarayana is another well-known advocate in criminal matters at that time. He appeared for the accused, the second accused. So in the case, under order 250 and 253 of the CRPC, it's a procedural thing that in a case where compensation was ordered to be paid in spite of the complainant's request for examination of his witnesses, whether it is legal or illegal. என்ன பண்ணாங்க, the plaintiff witness, the complainant, it's a criminal case. Complainant witness examine பண்றதுக்கு முன்னாடியே மேஜிஸ்ட்ரேட் என்ன பண்றாரு, நீங்க பண்ண கிரைமுக்கு இவ்வளவு அபராதம் கட்டிடுங்க, நான் உங்களை ஐ வில் discharge யூன்னு சொல்லி ஆர்டர் பாஸ் பண்ணிடுறாரு. Whether such a procedure is correct or not, before giving an opportunity to the complainant's witness. So the matter was argued. Though the bench said, yes, procedurally speaking, the magistrate was right, but when the complainant has filed a petition to examine the witnesses, the magistrate need not have passed an order of acquittal after paying compensation without examining the complainant's witness. அதுக்கு என்ன சொல்றாங்கன்னா, that the wordings was the code on CRPC, the code provides for a record of his objection, and it seems to us that the position is made by the words of the code are stronger than that of the complainant, against whom sanction for prosecution for an offence under section 182 or section 211 IPC is sought. And in such cases, this court is always required that a notice and opportunity to meet should be given to the party and permitted to adduce evidence, though 195 has no such provision. We think that the magistrate should have allowed the complainant to call for his witnesses for examination before passing an order of compensation. So, finding that, they set aside the order of the magistrate, and the evidence, all the evidence was ordered to be taken by the prosecution. Whereas, in a summons case, only after all the evidence of the prosecution was taken. An acquittal in a summons case could only be done after all the evidence of the prosecution was taken. In a warrant case, this can be done only after the charges are framed. They give a principle. Therefore, we set aside the order of the compensation. They remand the matter back to the magistrate for examination of the witnesses. So this was one of the other cases. It was also clarity of thought, how clear they were. The next case, which I am going to talk to you about, is also another civil case, an interesting civil case reported in 1921, volume 40, page 486. This was also it's a civil matter where it was a bench headed by Justice Sadasivaya and Mr. Justice Napier. இதுல என்னன்னா Hindu law, joint family business. Okay, in a joint family business, when a debt is incurred for the business and subsequently a partition takes place of the joint family properties, what is the liability of the members of the family? Whether the share of one of the members should be taken into account to discharge the debt of a third person. So, in the case, what was the proposition that was held by them was where a debt is contracted for the purposes of a joint family business, the share of one of the members of the family after partition is liable for the debt, though the suit for the recovery of the debt is brought after partition. So, this is the proposition of law. In the case Muthu Reddy versus Chinnasamy Reddy அப்படிங்கிற ஒரு கேஸ்ல this proposition was upheld by Justice Sadasivaya and Justice Napier. இது என்ன ஒரு இந்த கேஸ்னா, this was a second appeal against the decree of the court of the additional temporary subordinate judge of Kadalur in AS number 123 of 1918 on the file of the district court of South Arcot. And this was preferred against the decree of the district municip of Panruti, Kadalur in OS number 83 of 1914. இது என்ன இந்த propositionல they followed the case law laid down in the case of Ramachandra Padayachi versus Kondaya. It was reported in 1901 ILR page 24 Madras. ILR 24 Madras page 555. இதுல இந்த கேஸ்ல இன்னொரு doyen of the bar, Justice K. Bhashyamayingar, who also became a judge of the Madras High Court, appeared for the respondent, and Srinivasa Gopalachari appeared for the appellant. இதுல there are only two parties. One, the second defendant was the appellant, and the respondent is the second plaintiff. Others, the first plaintiff and the first defendant were not made parties in this suit. The facts are briefly: the first plaintiff obtained a personal decree against the first defendant, that is the brother of the second defendant, for a sum of money due to the plaintiff by both the first and the second defendants who carried on the family business. And the debt was sued on because it is a family debt. It was owed by both the defendants. The first defendant contested the decree and he lost. The second defendant was set ex parte and ex parte decree was passed. And the ex parte decree passed பண்ணும்போது the family property belonging to the second defendant was attached. The decree contained two reliefs. The decree என்ன பண்ணாங்க? The decree was then assigned by the first plaintiff to the second plaintiff. There was an assignment of decree by the first plaintiff to the second plaintiff. And the second plaintiff was recognized by the court as a decree holder because of an application filed by him in the execution petition. So, this is the background. Then again, the ex parte decree was set aside. The matter was contested again by the second defendant. Of course, he lost the case. And the case, என்ன சொன்னாங்கன்னா, the district municip gave a decree for only half the suit amount against the second defendant and made him liable as before to the extent of the family properties in his hands. The defendants 1 and 2 have effected partition after the family debt was incurred, but before the suit was brought. The lower appellate court confirmed the decree, hence the matter was taken up on second appeal before the Honorable High Court by the second defendant, in which he has impleaded as respondent the second plaintiff alone, not the first plaintiff. So, இந்த மாதிரி ஒரு proposition வரும்போது The contention on the appellant side is that the courts below had no right to award any relief to the assignee decree holder. That is the second plaintiff. The decree of the first plaintiff was assigned to the second plaintiff, which the second plaintiff obtained as an assignment of the subsequently set in an ex parte decree. The decree therefore ceased to exist. அப்படின்னு அந்த வாதம் நடந்தது. They said that there was no decree at all because it was an ex parte decree, and then subsequently it was contested on merits and he lost. And they held that the court was not justified in giving decree in favor of the second plaintiff on the claim and on the right which was revived in favor of the first plaintiff alone. So this was the brief facts of the case. And the subsequent in fact the property was also partitioned, and the share of the property of the second defendant cannot be brought for sale or attachment. So hearing all these propositions and arguments, the Justice Sadasiva held as follows. It seems to me, therefore, that when the second plaintiff got the assignment of the decree, he became ipso facto clothed with all the rights of the original decree holder. That is the first plaintiff, which could be enforced by him for the protection of his rights under the decree and for obtaining any fresh decree if that decree is set aside, and further entitled to stand in the shoes of his transferor for all purposes connected with and legally flowing from the right transferred to him. Therefore, he refers to sections 8, 44, and 73 of the Transfer of Property Act, which are based on this same juristic principle. In fact, the second defendant has himself recognized such a right in the second plaintiff when he pleaded him as a co-respondent with the first plaintiff in his application to set aside the ex parte decree. So the second defendant, while filing an application to set aside the ex parte decree, has also joined the second plaintiff as a respondent. So when the second defendant himself recognizes the rights of the second plaintiff has got all the rights to proceed against the property of the second defendant. Eventually, he gives a very clear proposition of law. And the memorandum of cross objections were filed by the second plaintiff, and the cross objections were allowed, and the defense put forth in the cross objections by the second defendant was dismissed. So this is another example of the clarity of thought of Lord Chief Justice T. Sadasiva, who had given several judgments on Hindu law and the other laws also. The other case, interesting case, which I shall, it is called the religious endowment mud case. That is Lakshmi Tirtha Swamya minor versus K. Raghavendra Rao. It is a mud case. That is the sannyasi, the head of a mud. How far is he liable in a suit for recovery of money owed by the mud to the third party? This again, this decision was given by Justice Sadasiva sitting with Justice Spencer, and which is one of the landmark judgments regarding this. The brief background is, in a suit to recover simple money debts by the sannyasi, head of an institution, the trust itself can be made liable, and it is immaterial for this purpose whether the suit is brought during the lifetime of the trustee who incurred the debt or against his successor. In such a suit, the creditor must prove that not only the monies were borrowed for the purposes of the trust, but there was an existing necessity for them to incur the debts. That is, the necessary expenses could not have been met out of the income of the mud funds which were available to the trustee. A Hindu sannyasi has no personal credit whatever of a monetary or a proprietary character, and the principle of the decision in Swaminatha Iyer versus Srinivasa Iyer and Chidambaram Pillai versus Veerappa Chettiar were inapplicable when the question of the liability of the mutt or other institution for the debt incurred by a sannyasi as the head of the institution comes into question. So, just as Sadasiva held, the principle of the said decision would apply even to an ordinary trustee of a temple who is not a sannyasi trustee. Eventually, he upheld the order. The defendant, what are the brief facts are? The defendant is the appellant. The appellant is the Swamiyar, uh, who was who owes a sum of rupees 1,500 and interest thereon on the loans advanced to the head of the Shirur Mutt, one of the 8 Udupi Madams. The Swami to whom the loans were made is dead, and the suit was brought against the successor. The allegation in the plaint being that the debts were incurred for the benefit and necessities of the Mutt. The plaintiff prayed that a decree should be passed during directing the defendant to pay the sum to the plaintiff out of the estate of God Vitala of the defendant's madam. The district municip found that of the 76 items making up of rupees 1,500, the third item was clearly proved to have been borrowed for the necessities of the madam. As regards the other items making a sum of rupees 1,000, they were borrowed from him for the ordinary expenses of the madam. But the creditor has not shown that the means then in the hands of the Madadipati were not sufficient to meet the expenses. So he therefore gave a decree as regards rupees 500 against the defendant as the representatives of the madam to be recovered from the rents and profits of the madam. But as regards the remaining 1,000 and interest thereon, he directed the defendant to pay it out of the assets of the predecessor in his hands, such assets, according to the district municip, consisting of income which accrued from the mud properties during the lifetime of the defendant's predecessor. The district municip informing such an opinion was guided by the view of law as it was as it stood in the case of Ram Prakash Das versus Ananda Das and Arunachalam Chetty versus Venkadachalapati Guruswamigal. That view being that the head of the mutt is a private and absolute owner of the income of the mutt accrued during his lifetime. So this was again several points were argued, but of course the order of the uh, district municip was upheld, and where Justice Sadasivaya, speaking for himself and the bench, said that the principle underlying the decisions is that such a trustee or other person in the position of a trustee has got his personal credit to pledge. And the presumption should be that when he incurred a debt without charging the trust, the same has to be the creditor lent the money on such personal credit and could look to the credit alone and to the principle of subrogation for recovery of his loan. I think the same principle would apply even to an ordinary trustee of a temple who is not a sannyasi. But as regards sannyasi trustees, a distinction has been suggested in the case of Shankar Bharati Swami versus Venkappa Nayak. It was reported in 1885 ILR Bombay. I shall quote the following sentence. அப்படின்னு சொல்லி அவர் என்ன சொல்றாரு? The case as is said to be similar to that of an executor contracting a loan for the purposes of the estate by the English law, or that of the manager of a charitable institution incurring a liability for the purposes of the institution. So, without his credit being pledged, nobody will give a loan to a a mad, because it is the credit worthiness of the Madadipati which makes the creditor lend money to the Mada. So அதுல என்ன சொல்றாருன்னா, இப்போ ஒரு மடாதிபதிக்கு பிரைவேட் ப்ராப்பர்ட்டியே இல்லைன்னா, ஃபார் த டெட் இன்கர்ட் பை ஹிம் தி மட் ப்ராப்பர்ட்டிஸ் வில் பிகம் liable அப்படின்னு சொல்லி, only because of the credit the third person gives the money அப்படின்னு சொல்லி. Similarly, again in Nataraja Desikar versus Karutha Ravadan, the ultimate decision was in favor of the successor of the Mutt, who was a defendant in the case. The law laid down recognizes that the loans incurred by the head of the Mutt for the necessary purposes of the Mutt can be treated as pledging the credit of the Mutt and as justifying a decree against the Mutt. So I find from the back of the printed papers in that case that Shankar Bharat Swami versus Venkatappa Naik was cited before the learned judges, and though the loans in question in that case were obtained by the head of the Mutt by merely signing acknowledgements of indebtedness in the plaintiff's account books, the judgment proceeds on the footing that the hereby pledges the credit of the Mutt and not any personal credit of his. And clear that a Hindu sannyasi has no personal credit whatever of a monetary or a proprietary character, and that it is a contradiction in terms to the state that any loan taken by the Madadipati can only be for his personal use. I would therefore hold that the case in Swaminatha Iyer versus Srinivasa Iyer and other cases already referred to do not apply when the question of the liability of the Mutt or other institutions for the debt incurred by a sannyasi as head of the institution comes into question. In the result, I will dismiss the second appeal with cause. So this is how there's another landmark judgment which was pronounced by Justice Sadasiva Iyer in this case, reported in 1920, volume 39, 1920, volume 39, page 174. You can refer to this, it's available. And the other, so these are some of the judgments of Mr. Sadasiva Iyer, um, heading the bench of the Madras High Court. And in 1921, he retired as a judge of the Madras High Court, and later he died in December 23rd, 1927. So these are some of the important decisions of Justice Sadasiva Iyer, and I'm sure all of you would have enjoyed this particular session of another Doyen of the bench, which many would not have heard, and many would not have probably know the clarity and capacity of such a judge.